Hi everybody, welcome back to Law Hero. My name is Jen and today we are looking at legislation in Ireland and how legislation is made, what the process is, what's the product, primary and secondary legislation. So what do we mean when we say legislation? So basically any law that originates from a legislative organ in Ireland, that is our upper and lower house, the Oireachtas and the Seanad, is legislation. And you cannot have laws without a power to create them. So in Ireland we have Constitution, Bunrat na hÉireann, and then we have Article 15.2.1 of the Constitution is the power to create legislation. And that article says that the sole and exclusive power of making laws for the state is vested in the Oireachtas. No other legislative authority has power to make laws for the state. Sorry, I meant to say the Seanad and the Dáil. So Seanad are senators, Dáil are TDs, Teachta Dála, members of parliament. So legislation falls into two categories. It can be primary, and usually we call this statutes. We call them statutes or acts of the Oireachtas. And acts of the Oireachtas fall into three types. So we can have an act to amend the Constitution. We can have a public general act, which is the laws for the public at large, and this is the most usual one. And then we have private acts for a few individuals, such as companies or local authorities, like for example the credit union acts. Secondary, subordinate or delegated legislation is all the same thing, and it is obviously the opposite to primary legislation. And these are measures enacted by a person or body to whom the Oireachtas has delegated legislative authority. And it's like the detailed rules that come with the legislation. So let's now look at the characteristics of legislation. Obviously, usually because of legal certainty, it will be written down. A legislative rule is stated in an inflexible manner and no linguistic variations can be substituted. This contrasts with common law rules. And also when a judge is applying the law, it is done in a very strict manner. A second characteristic of legislation is that rules tend to be stated in a precise rather than general form. However, this is not universal and there may be some open-ended terms. So in the usual sense, a judge will interpret the legislation and the legislator will have tried to cover off any eventuality, loopholes by way of secondary legislation, or they might have schedules to the legislation. But more often than not, there might be some specific direction to the court. For example, like there might be a comma and it might say as the court may decide or as a judge may decide, and that is also done by way of inserting the word reasonable, because that leaves the provision open to interpretation. So let's now look at the legislative process. So in Ireland, the legislative organ established by the Constitution is the Oireachtas, which consists of the upper and lower house, and the president. So you have the Oireachtas, which is Dáil Éireann and Seanad Éireann. They enact the legislation and then it's signed into law by the president. The relationship between the two houses is regulated by the Constitution, which preserves the supremacy of the Dáil, as those people are directly elected by the Irish people. Primary legislation other than a money bill may be initiated in either house when the proposed act is known as a bill, but the Dáil enjoys the power in effect to overrule the Seanad. Where the Seanad rejects or amends a bill which has been passed by the Dáil, Article 23 of the Constitution says that the Dáil may pass a resolution which deems the bill to have passed through both houses. If a bill was initiated and passed by the Seanad and it's amended by the Dáil, it is deemed to have been initiated in the Dáil, just requiring fresh consideration by the Seanad. And Article 23 has only been invoked on 2 occasions. And this kind of shows a weakness of the Seanad. The first obviously in relation to money bills, and the other one is they only have 21 days to make their recommendations, which then may be accepted or rejected by the Dáil. And this comes back to the American phrase where there is no taxation without representation. And that means, of course, that all financial matters fall exclusively within the ambit of the Dáil. And I suppose that is a nice throwback to kind of constitutional history of the world, and it's nice. I mean, if you think about the founding members of our state, like Eamon de Valera, would have been greatly influenced by the American War of Independence, so that's where it comes from. And also Article 24 of the Constitution provides a procedure for the abridgment of time to allow the Seanad to consider a particular bill. Once Article 24 is evoked, the bill is deemed to have passed through both houses on the expiration of the specified time, and again, I suppose that is some kind of a weakness. In practice, the Seanad has tended to facilitate the speedy passage of urgent legislation, and Article 24 has not been invoked to date. On being passed by both houses, the bill is presented to the President and is signed into law, usually between 5 and 7 days of being passed. A bill becomes law, that is, an act theoractus, on the day it is signed by the President, who is required to promulgate the publication of a notice in the Iris Ifigul, or in English, the Official Gazette. And there's a different procedure if a bill is seeking to amend the Constitution. In 2 circumstances, a president may decline to sign a bill. This is under Article 26, and there has been a few. Under Article 27, there's a procedure under which the president may decline to sign a bill deemed under Article 23 to have passed through both houses, which contains a proposal of national importance until the will of the people has been sought. Which would either be a referendum or a resolution of the Dáil after dissolution and reassembly of the Dáil, thus indirectly discerning popular sentiment on the measure. So just so you know, the internal workings of the Oireachtas is governed by standing orders. And they have a thing called pre-legislative scrutiny, or PLS, and that has actually 5-stage process of the bill to pass through Parliament, and that's provided for in the standing orders, if you didn't know. So what is the 5-stage process? So firstly, the minister responsible, or the member of the House, in the case of a private member's bill, obtains the permission of the House to circulate the bill. The second stage, the general provisions of the bill are debated. At the third, or committee stage, the details of the bill are debated. The fourth stage is the report stage, and its purpose is to review the work which has been conducted at committee stage, and the fifth or final stage is to complete the process. So let's take a little bit of consideration around the legislative product, i.e. what is the end result of the legislative process. Now, most people would be quite familiar with the Irish Statute Book. You go on, you look for the Act, and there may have been some amendments, the Law Reform Commission, but in truth, from an electronic point of view, it isn't great. We don't really have we don't really have like a proper database where you can see every single amendment and you can see the consolidated legislation. You can only really do that if some other body has gone and done it. For example, there's a private company called Better Regulation. They will show you the amendments to regulation. They've done it painstakingly. Or the Law Reform Commission has some consolidated legislation. But in my opinion, this should be provided by the state, and it should be a priority. But I suppose it would take a lot of people to try and help them do that. Most bills are introduced and passed in the English language. Bilingual and Irish language bills are rare exceptions. Article 25.4.4 of the Constitution requires that an official translation of laws passed in one language should be provided. So a statute has a short title by which it is generally known and cited. For example, the Misuse of Drugs Act 1977. But a long title would be, for example, an act to prevent the misuse of certain dangerous or otherwise harmful drugs, to enable the Minister for Health to make for that purpose certain regulations in relation to drugs, blah 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 blah. The long title, in very general terms, sets out the purpose and objectives of the statute. And then you will have a preamble as well. That was usually in the past, but they're not really there anymore. You will have a date of commencement, so like this act commences on. So you need to know the difference between the date on which it was signed into law and the date on which the act commenced. For example, the Companies Act was signed into law on the 24th of December 2013. The 23rd of December 2014, but it wasn't commenced until June 2015, which was the best day of my life. Okay everybody, that was a very quick video on legislation and the legislative process. I didn't want to go into too much detail, but the next day I am going to focus on so the next few videos I have coming up are the Constitution, the Constitution, legislative interpretation, EU law and international law. So I hope you're enjoying this Back to Basics series, and I will see you in the next one.